Um, Welcome to the event. So, Mr. Kishore Mandyam will be giving the welcome speech. So, I invite Kishore to give us a welcome speech.
Thank you. Thanks, Arnav. Um, as a non-lawyer, man on the street, the Constitution worries me, right? It worries me when I see grieving parents put in jail for 9 years. It worries me when I see a driver beaten into submission and admitting a crime that he didn't commit. But then I also think that this 90,000 word document put our second longest serving prime minister into jail for a crime she did commit, right? And among our neighbors, it's probably the single biggest contributor to keeping us from sliding into a den of tribal rivalries, because we have enough tribes in this country. Right? But at DAKSH, we looked at the Constitution and we said, there is a much more immediate value to it. We need a platform where we can actually get together and reflect on issues that are more current, more relevant. We've done this for 6 years now. This is the 6th year. And this year, we have a doozy. We have an issue that is affecting every one of us. Again, as a technician, as a technologist, I look at privacy and I say, what's the big deal? I roll out some software, firewalls, hardware, make sure credit card numbers are not stolen, and we are done. But then I get that SMS from Airtel, which says I have to put my Aadhaar number next to my telecom number. And I'm saying, really? This worries me. But I have no knowledge about these things. And I'm hoping that today, with Mr. Arvind Datar talking to us about privacy in the digital age, I will learn something, and I'm looking forward to a lot of conversation. We also have the release of our 2017 Access to Justice report, which last year did very well. We got very good feedback from people who read it, who put it together and contributed to it, and so on. And this year, we're hoping it'll be even bigger. So without much ado, Harish, over to you for the release. And welcome, everybody. Syria? The books?
Thanks, Kishore. So we're very privileged today to have in our midst one of the senior most practitioners in the city of Bangalore and a legend in his own right, Mr. B.V. Acharya. So we think it's fitting that we request him to kindly release our report. Mr. Acharya, please. And sorry to spring it on you at the last moment. Mr. Datar. Sir, please, sir. Sorry. I'll take 5 minutes to explain, to briefly tell you what this report contains and how different it is, partly from the, I'm sorry, okay. How different this report is from last year's report. As those of you who have been following our work know that last year we released what was called the State of the Judiciary report, essentially documenting data around how the judiciary functions. So for the lawyers amongst us, the focus was not on substantive justice, but the process, because we all know that judicial delay is a fact of life in the country. And as Kishore referred to it in his brief introduction, it's something that has overtaken our judicial system and is actually threatening even the qualities of substantive justice that we stand for. For example, a fair hearing. How fair can you call a hearing if you're only being given half a minute or sometimes half a second to either say something or it will get postponed to another date. So when we started working on what we call the Rule of Law project, the idea was to collect data so that we can understand what this judicial delays problem is all about, and to analyze it in a manner that becomes helpful for policymakers to suggest proper changes. So last year's report was very well received. We sent a copy to every High Court judge in the country and the Supreme Court judges. Because of that, a lot of new experiments are being carried out in a few states, some of which are still in the works, some of which will be announced probably shortly by the High Courts themselves, where they're trying to see what can be done to improve day-to-day efficiency of the subordinate courts. Because I think for us to go and suggest something in the High Courts, I think we still have a long way to go. But subordinate courts, we have made some move forward. Last year, we had also conducted a survey amongst litigants in about 300 district courts across the country to understand the common man's view of the courts. This year, the report is not titled State of the Judiciary, but it's instead titled Approaches to Justice in India, partly because we did a major survey, and the first part of the report on the survey is contained in this book, covering about 46,000 households across the country. The idea was to check how many people access courts in this country, and if not everybody is accessing courts in this country, what happens to the problems? And one of the main findings of our survey is less than 5% of the total population actually come to courts. And if that is not astonishing enough from a rule of law perspective, where do the other 95% go is the more important question. And our survey answers some of that. And it's a very interesting read. We have just analyzed the major findings and included in the report. So I would urge you all to take a look at it. In the coming months, we are planning to release more and more details of this, the report. This year's report contains about 4 sections. The first one is about the survey and the search for justice. So what is the search for justice? What does justice mean? There's a very provocative article by a non-lawyer. Ashwin Mahesh is not here today because he's traveling, about what is the sense of justice in this day and age in our country. Then we have the findings of our survey, which we call the paths to justice. There's another very provocative article by the Swamiji of the Chitradurga Pita, who conducts every Monday what he calls an informal mediation session. And courts have actually recognized his proceedings as an arbitration proceeding. And unlike other alternate means of justice where no principles are followed, or religious principles which are not in consonance with the Constitution are followed, this proceeding is something to be believed. And he is doing it without a break, I think for the last, Aruna knows this detail, for the last how many years? 10, 15 years. And we have got a recording of that, which we hope to release at some point of time. There's also an interesting article on Gandhi's juris conscience by the former Vice Chancellor of the Gujarat Vidyapith, Mr. Sudarshan Iyengar. In section 2, we have more details on the delay facing the high courts and the subordinate courts, and we've also included what we call as the top 10 measures that we need to take for maximizing judicial time and improving justice. In section 3, we look at some of the specific case types. For example, we all talk about, all the newspapers carry details on check bounce cases and how long it takes. So we have analyzed some data as to what are the problems, where do they get stuck, and all of that. There are also studies on tax litigation and how government reacts to tax litigation, a case study of a tribunal in Karnataka, and also an article by an American scholar called Leah Rose Goodwin, who talks about how courts in California manage and administer their judicial system. and the case flow there. In the last section, we have views of a judge, a sitting judge of the Madras High Court, Justice P.N. Prakash, who talks about the kinds of cases that come before him. We have a prosecutor again from Tamil Nadu, Judy Angelo, talking about a prosecutor's views. We have Mr. R. Srikumar, the former DGP and IG, talking about the challenges of criminal investigation and how trusting the police is important for the criminal justice system. And we have an interesting empirical paper on the judicial tenure of judges in the Supreme Court, the only paper in this book that focuses on the Supreme Court. And we have a couple of economists who have written on how judicial budgets are made. So I won't go any more into the details. I would urge all of you to read it. Again, this time we are planning to send this to all the sitting High Court judges, the Supreme Court judges, and other prominent policymakers, including lawyers. So today, because the book came to our hands only a few hours ago, so we have about 100 copies outside. I would urge all of you to buy it if possible, because it will at least cover our courier charges when we send it to all the High Court judges. Okay. Thank you very much. That's all about the report. Now, I request Mr. Arvind Datar to deliver the Constitution Day lecture. Incidentally, Mr. Datar was also present at the release of our first report last year in Delhi, so I think hopefully his presence will make sure that this report also faces the same amount of success. If you want to sit, you can sit. Or
You can hear me, right? Yeah. So I'll just keep the mic slightly this way. So this is Jugaad. Can you hear me at the back? Yes. I must thank DAKSH for inviting me to deliver the Constitution Day lecture. I think 26th November is our law day, and they asked me to speak at this year's function. In a not very happy state of affairs, the judgment of the 9 judges on right to privacy was perhaps a really welcome silver lining to the judicial cloud. Now, I decided to speak on this because it is extremely topical, and we expected the Aadhaar case to start on Tuesday, but I don't know whether the Delhi matter is going to go on, but then we're going to start the Aadhaar case immediately. I think you mentioned that you don't know why your bank account has to be linked with Aadhaar. Even I don't know. For the life of me, I was asked to be a director of an NGO, and they said you must have your Aadhaar number. So I'll come to that part later. But this whole debate on the right to privacy started on the 11th of August of 2015. By that time, Aadhaar was being implemented by executive instructions. And the Supreme Court said that, look, you can't have Aadhaar for not more than 6 items. That is your ration card, gas connection, 3, 4, 5 items were there mentioned by the Supreme Court. As the hearing was to start, the Attorney General made a statement that there is no fundamental right to privacy in India. The moment he said it, the judges told him, on what basis are you saying it? And he referred to 2 judgments, one of 1954, which was rendered by 8 judges, and one in 1962 rendered by 6 judges. It's odd that they were of even numbers, but that's how the strength was. Now, so once this statement was made by the Attorney General, the senior most, the law officer of the country, the judges said, okay, we'll refer it now to the Chief Justice to constitute an appropriate bench and decide whether at all there is a fundamental right to privacy. Frankly, as a lawyer, I thought this was a clear delaying tactic, because by the time the Constitution bench decided whether we have a right to privacy, it was the 23rd of August 2017. So 2 years passed, and from some 10 or 20 crore Aadhaar card holders, we came to 100 crore Aadhaar card holders. It is also astonishing that he said that there is no right to privacy, because if you check SEC, you will find that before the RR judgment, there are 64 Supreme Court cases where they have used the word right to privacy. So there was really no debate. But why did it happen? I'll first deal with that, then I'll also discuss briefly the law of privacy, and then I'll go to the right to privacy in a digital age. You see, in 1954, just see how events turn and lead to momentous occasions. In 1954, the Dalmia company was raided. Those of you who are lawyers would have heard of Aram Krishna Dalmia. Right? The industry went to the dogs, but at least they had some contribution to develop the law. So I keep telling my friends from Calcutta, I said, if you don't have industry, at least you have developed the company law. So anyway, in 1954, the Dalmia company was raided, and the Department of Company Affairs seized some records. He said, you can't seize those records because they violate my right of Article 20, it will be a question of self-incrimination. 23 is a bar against the search, a simple point. Supreme Court obviously said that there is no question of your fundamental right being violated, you have violated the Companies Act, they have seized some record, what is the big thing about it? But in that 8 judges judgment, Justice Das makes an observation, passing, saying that unlike the 4th Amendment in the US Constitution, we do not have a right to privacy. So he said India doesn't have a fundamental right to privacy. That statement was there. Now, ironically, if you see the 4th Amendment to the Constitution, the word right to privacy is not used anywhere in the US Constitution, nor in the Indian Constitution. What the 4th Amendment says is, you know that the US Constitution came in 1776 and all the rights subsequently came in 1789. And the 4th Amendment says, briefly speaking, that your house cannot be searched. There's a bar against unlawful searches of a person's home, his physical space. And that really is based on Lord Coke's dictum that every man's home is his castle. So this was an observation saying that unlike the 4th Amendment, we don't have a fundamental right to privacy. End of the story. 1962 came that historic case of Khadak Singh, where what happened in the UP, in the state of Uttar Pradesh, the police could do 4 things. They could have surveillance over you, they could maintain your records, they could ask for your, ask you to come for inspection, and the last and the most dangerous was they could make domiciliary visits were permitted. Now these domiciliary visits were done at night, and Mr. Khadak Singh was admittedly a person with a criminal record. He complained to the Supreme Court that, look here, the daroga, the police officer, comes to my house at odd hours of the night and asks me where did I go, what did I do, who came to my house, and so on and so forth. And he said, this violates my right to privacy. Now in this subsequent Khadak Singh case, it's a judgment of 6 judges. There they say the UP police can ask for records, they can maintain records, they can ask you details, but they struck down the provision regarding domiciliary visits. They said visiting a person at odd hours is completely unconstitutional. So these are the 2 cases which then, and then after that there was nobody bothered about the right to privacy. Our Attorney General said that India doesn't have a fundamental right to privacy. Just a few historical background of the US Constitution which will tell you, the topic is right to privacy in a digital age. And you will find that this right to privacy is going to be from the, not only Stone Age, but the electric age, the information age, digital age, and I don't know what future age is going to be ahead of us, and how the right to privacy will be all pervasive. And look at the fascinating way in which the courts have developed the right to privacy. Now, as I said, the 4th Amendment really says you can't enter a person's home, cannot search it. So it's a case of not invading a person's physical privacy. In 1926, the first question came, Olmsted versus the United States, where that was the day of prohibition. You know that the US prohibition was a big thing. In fact, people say that was the start of the mafia and so on and so forth. Incidentally, Joseph Kennedy made his money in the prohibition days. But this was the date of prohibition. And this man's phone was being tapped by the FBI because he was a bootlegger. The question arose whether phone tapping amounts to violation of a right to privacy. And the US Supreme Court said, the right to privacy is only regarding your home. They have not invaded your home, they have not searched your home, they have tapped your conversation. So wiretapping is not a violation of a person's right to privacy because privacy means physical space, physical privacy alone. That was 1926. But those of you who are lawyers, please read the dissenting opinion of Brandeis. With remarkable foresight, he says, we are getting into an age where newer devices are being devised. We do not know where it will lead us. And what a man says in his closet can soon become known to the entire world. So what you say in your bathroom can be known to the world. He says in 1926. So, but Brandeis, in fact, Brandeis wrote the article in 1890 in the Harvard Law Review, where he said the most important right is the right to be left alone. Chandrachud has pointed out that it's not Brandeis first, but some other author has mentioned it earlier, but that's a different story. But the most important right to privacy is the right to be left alone. So Brandeis points out that, look, we are coming into an age of technological development. What you say in the bathroom can be known, so this is a very dangerous thing. I don't think that we should permit wiretapping, but it was a voice in the wilderness. And it's a very funny thing of the law that very often dissenting opinions become landmark judgments later. Right? Whether it is Fazal Ali's dissent in A.K. Gopalan, or it is the dissent of Khanna in JDM Jabalpur, all these become the law later. Now fast forward to 20 years, we come to Katz versus United States. Here what happened? After the war, gambling was a major vice. And Mr. Katz used to transmit the bets, etc., on the phone. So what they did was, they knew they were following cats. Again, they were following cats. So they used to know that he goes into a particular phone booth and makes calls. So they put a bug in that phone booth so that they could tap his conversation. So you'd go in, make a call and so on. Now the question was whether putting a bug and recording his conversation is a violation of right to privacy. What do you think? Now the Supreme Court said Olmsted is wrong. When you talk of privacy, it is not a person's physical space, it is his personal space. When he goes into the booth and closes the door, that is his private space. What he speaks, to whom he speaks, what he says is entirely a matter of privacy. You can't record it unless you have an authorized warrant. So Katz was a major decision where they departed from the physical space and went into the case that a man's privacy is not just invading my home and so on, even what you talk, etc., that is entitled for privacy. Then of course the matter goes on further, I won't go into details, but I'll tell you why I mentioned this, because when this Aadhaar case was, the privacy case was being heard, Chief Justice Kher told us that we don't have much time because he was retiring in August, and he asked us to ration or divide the time amongst us. So I was given the task of covering the US law on the subject, and that's how I could make a more detailed study of that. We had studied very cursorily in the law college, but when we studied this, we found out that privacy which was mentioned in 1789, see how it develops. From a mere house, it goes to wiretapping, it goes to tapping of a phone, and then it goes into other areas of human conduct. The right to privacy goes into other areas of human conduct. Let's give two examples and I'll move on. I was shocked to note that till 1965, it was illegal to sell contraceptives in the state of Connecticut. That was challenged in the Supreme Court, Griswold versus Connecticut, another landmark judgment, where they said that my right to privacy includes my right of procreation, my right of having my relationship with my partner, and what I do personally is of no concern to anybody. They struck that law down. And mind you, the contraceptive could not be sold even to married couples. Then 1972, the law continued that you couldn't sell it to unmarried couples. That also was struck down. So in the US, mind you, in 1972. So this was the law. It's difficult to believe, but this is how. But what I'm saying is, look at how the law of privacy is extended not only to these electronic items, but to areas of personal incidents. Compulsory sterilization of hardcore criminals, again struck down. And I'll just conclude with Roe versus Wade and then go on to the Indian cases. You know the Roe versus Wade, the famous case of abortion. Now before I go further, just keep in mind that when I speak on privacy, there are broadly three categories of privacy. And I must tell you that we got this suggestion from an LLM scholar in Cambridge from India who has written a thesis on privacy. And she has divided into 3 parts. What are the 3 parts and which has been accepted by our Supreme Court? She's quoted in the judgment. One is physical privacy, physical space. Second is informational privacy, information about my life, my body. They need, like, you can't publish a book giving intimate details about me. That will be completely in violation of my right to privacy. And lastly, decisional autonomy. So you have physical privacy, informational privacy, and decisional autonomy. These are the 3 categories. So if you keep this in mind, it will be easier to follow the lecture. Now come to Roe versus Wade. Very, very, very vexed question in the US, because the huge group of religious people say that there's a right to life, you can't take away a right to life, it's something which God ordained, and so on and so forth. But if you see Roe versus Wade, they finally resolved the matter in a balanced way. What did they say finally in Roe versus Wade? They said a pregnancy is divided into 3 trimesters. In the first trimester, complete autonomy to the lady. She can decide whether she wants to have the child or not. Second trimester, yes, she has the right, but only under medical supervision in a state-approved institution. And the last trimester, not permitted at all, unless it is going to be harmful to the mother. So this is how Roe versus Wade struck privacy. Now you will realize where privacy has gone from your home to wiretapping to this to finally to abortion. And there are many, many more cases where it has gone. I'm not getting into all the other details. Now come to India. What are the examples of privacy in India which will show how the law is developed? Apart from this case where they said no right to privacy, there were other cases which were being decided before this 9-judge bench, recognizing the right to privacy. Where in some cases they said you have no right to privacy, you have some right to privacy. I'll give you one example where they said that the person's right to privacy was negatived. And that came from Madras, Tamil Nadu. It's called X versus Hospital Z. I don't know if you have seen X versus Hospital Z. Very interesting case. 3 people came from Nagaland. One of them was a doctor who was an MD, postgraduate doctor. His relative had to be treated in Chennai. You know, for very many years, Madras used to have patients from all over, particularly from eastern region. So he had come with his relative who was to be treated, and another attendant had come with them. Now this patient, his relative, required blood. So both these gentlemen, the MD and the attendant, gave blood. They found that this MD's blood was HIV positive. Now the doctors revealed it to his fiancée. He was engaged. He said, you have no business to reveal my data. It's my personal information. You should not have revealed it at all. The Supreme Court sorted it out by relying on 2 sections of the IPC, where it says that if, as a result of my illness, I am liable to create infection to others, that's a punishable offense. And the hospital was duty bound to prevent that offense. And the Supreme Court says, just as your right to privacy is important, your fiance's right to life is equally important, and therefore that mandates disclosing it. Take the next case from Karnataka. Selvi versus Karnataka, which is the famous narco analysis case. Now in Selvi, what happened was, the question was whether you can inject narco analysis, which popularly is called truth serum. I think it's sodium pentothal, that thing. Now I'm told that doctors tell me that if you use this particular drug, I mean, we have got 4 states. We are awake, we are hypnotic, we are in the awake state, in the hypnotized state, in the sedative stage, and in the anesthetic stage. These are the 4 stages which we have. Now when you give this particular truth serum, you will go into the second stage where all your defenses go down. It is expected, or it is rumored or felt, there are conflicting reports on that, that you start speaking the truth. In a very well-reasoned judgment, the Supreme Court finally said that you cannot administer this truth serum without the consent of the accused person. Although solving a crime, punishing the guilty may be an important social objective, but yet the person's right to privacy has to be protected. So this is a very important Supreme Court judgment where they said that they balanced state interest versus informational privacy and said, you do investigation, but don't inject truth serum against his wishes. One more judgment I'll give and then I'll go on to the Aadhaar and the privacy judgment. A very important case which has not been noticed for some reason or the other. This is on informational privacy. So this Selvi can be classified as a case of decisional autonomy. I may decide, I may choose to give my, I may choose to go for narco analysis. I have nothing to hide, you please take it, no harm. But I can choose not to. Now I'll go to one case of informational privacy. A lady was an unwed mother. She applied for the birth certificate of the mother and wanted to record her name as the guardian. The form said, what is the name of the father? She said, I don't want to disclose it. The matter went to court. She lost up to the High Court. And she said, I don't want to tell the name of the husband because he's already married. He's happily married. And if I put his name, his life will be in ruin. I don't want to spoil his life, but I still want to have the child. And I want the child in my name. High Court said, no, if you want a birth certificate, this is the rule, follow the rule. In a superb judgment, the Supreme Court struck it down and said, it is the choice of the mother to choose to reveal or not to reveal who is the putative father. If she chooses not to disclose a father's name, you must respect her privacy, respect her right to informational privacy. And they have directed all the states to say that wherever a mother wants, she need not mention the name of the father. You can't deny her the birth certificate on that ground alone. So this is the entire background. You will find how the right to privacy has gone on. And before I come to the digital age, I'll mention about this 9-judge judgment. Now, as I said, this 9-judge judgment is really a very well-written judgment. In particular, all have written well, but Justice Chandrachud's judgment, Justice Kaul, Justice Rohinton Nariman merit reading. And particular Chandrachud has analyzed the entire law, the US law, the South African law, the Canadian law, and has come to it. While upholding the right to privacy, one question was asked to us in the hearing was, where will you put the right to privacy in the Constitution? Now, like the US Constitution, the word right to privacy is never used in our Constitution. Where will you keep it? Is it part of Article 21, right to life? What is it? So one argument which I had made, or which we had made was, I said it could be in 25 also. Right to practice my religion, decisional autonomy. If I want to convert, if I want to practice my religion, that's a decisional autonomy. It could be in 21, it could be in 19(1)(a), it could be in 19(1)(d). Finally, the Supreme Court has accepted the point that the right to privacy is not only a fundamental right, it permeates and pervades the entire Part 3 of the Constitution. It doesn't reside in one article, it permeates everywhere. And this part we got from a judgment of Griswold, which is quoted by Matthew, saying that there are some rights which are laid down, and there are some rights which are a penumbra of rights. That is, there is a right, and around the right there is a periphery or a penumbra of right. We requested the court, don't say privacy is a penumbra right, it is a right by itself, and that also has been accepted. So, historically, it's a very, very important historic event. India now recognizes the right to privacy as a fundamental right. The government kept on arguing that at best it's a common law right. Now, what is the difference? Lay people ask me, what is the difference? Common law right and fundamental right. There's a world of a difference because once it's a fundamental right, then you can go to a writ court and get it struck down. For example, narco analysis, if right to privacy was a common law right, then you could not go to court under Article 226. You'll have to go to the city civil court and litigate and so on and so forth. And then you'll have to establish that common law right and so on. Now that it's recognized, it's a great thing. Now, 2-3 points of concern here. There is a right to privacy. How will it pan out in the context of Aadhaar? Historically, if you see throughout the ages, the basic conflict in entire constitutional law is the liberty of the individual citizen vis-a-vis the powers of the state. That ultimately is the basic conflict. I want my liberty. The state wants to curb that liberty in public interest. Sometimes it's necessary, sometimes it is not necessary. Justice Chandrachud has recognized it, Justice Nariman has recognized it, that your right to privacy can be curtailed in public interest, in the interest of security of the state, for prevention of crime, and all these arguments, none of us can say are not correct. Yes, you can. There's no absolute right to privacy. It can be read down, it can be curtailed, and so on. But now the question is, what happens to Aadhaar and what happens there? I argued unsuccessfully the earlier case, Binoy Vishwam, where, you see, our basic problem was the Attorney General undertook before the Supreme Court that barring these 6 items, we will not extend Aadhaar at all. But step by step, Ministry of Company Affairs says you can't become a director unless you have the Aadhaar card. As we speak, today I've got a notice from Axis Bank saying that if I don't give my Aadhaar card by 31st of December, my account will be closed. You have to give your, what they call seeding, you have to seed your Aadhaar account with the phone. Now just imagine, if you read Justice Chandrachud's judgment, I was surprised and actually very happy to note that India has 111 crore phone subscribers. 643 crore subscribers are in the cities and 400 approximately are in the rural areas. About 1 billion people have phones. Now if everybody's Aadhaar card is going to be seeded, look at the amount of data that will be floating around. What is the security you're going to say? I think your person mentioned about firewall and so on, Kishore. I don't know. Yes. Now, the legal point we argued was this, which was not accepted by Sikri, but it's again now coming before a constitutional bench. We said, what is Aadhaar? Why did Aadhaar start? If you see the history of Aadhaar, the UIDA project and so on, what they said was, we have a large number of subsidiary projects. Manrega is there, PDS system is there, XYZ. Now, how do we ensure that the subsidy reaches the proper person? What is called targeted delivery of subsidies, benefits, etc. So in fact, the Aadhaar Act is called Aadhaar in bracket Targeted Delivery of Subsidies and Benefits Act 2016. So the first argument was, your intention is to have targeted delivery. There is no act. You're just passing government instructions. So they made the act. Now if you see the act, section 3 says, you may apply for Aadhaar. Now in my case, personally speaking, I've got an Aadhaar because we had a gas connection and you couldn't get a gas renewal unless you had the Aadhaar card. Of course, subsequently under Modi's scheme, we said we don't want the subsidy. It's a different matter. But technically speaking, if I don't want any subsidy, I don't need the Aadhaar card. And my argument, our argument before the earlier division bench was, if a particular requirement is optional under the Parent Act, can it be made mandatory under the Income Tax Act? What they said was, in the budget, they introduced 139AA of the Income Tax Act and said, if by 31st July you don't give your Aadhaar card, then your PAN number will be invalidated. Now, with my limited intelligence, I still don't know how my giving or not giving my Aadhaar will make my PAN card valid or invalid. I've got a PAN card, say, for 20 years. And if you see Rule 114 of the income tax rules, to get your PAN card, you have to give you a passport. There's a very, very elaborate screening procedure. You can't just get PAN card like that. And PAN card is for companies, partnership firms. What happens to them? They have no thumb impressions. So what's the purpose in making Aadhaar mandatory for the PAN card? So our point was, if it is optional there, don't make it mandatory here. And that again we are arguing as far as the bank. Now the bank is a worse situation. They started making Aadhaar compulsory for all banks. I know of a relative of mine who's 84, who's bedridden in Pune, and they have told her that they'll discontinue account from 31st December. The manager said, you arrange for a wheelchair, do what you want, we can't come and give you the thing. We have no facility to take the machine there and take the thing. So what do you do? That's a big question, we'll have to sort it out separately. But I ask a simple question. If you have got, all of you have got bank accounts for 25, 30 years, what is the connection? What is the legal nexus between furnishing the account and invalidating the account? If my account has been operational for 25 years, and what I find is in the counter affidavits, again and again, the only theory of the government is we have to check terrorism, Jammu and Kashmir, black money, money laundering. I mean, you have to be incredibly foolish to think that if you attach Aadhaar to PAN card, you will avoid black money. You mean to say if a lawyer is taking fees in cash, by putting his Aadhaar card, he's going to take in check? I mean, you must be having a single digit IQ to think that PAN card, and this is seriously argued by the Attorney General. There's so much of black money. They said there are so many fake PAN cards. We got statements from the Minister of Finance in Parliament who said the total number of fake PAN cards is 0.4%. So I argued, I said, why are you asking 99.6% of the genuine people to put their PAN card and torture them? No need. Now, I'll talk about bank and I'll stop with this. Bank is a very, very sinister problem. Do you know under which provision they're making the PAN card mandatory under banks? PMLA Act. It is astonishing. One of the most badly drafted and most misused enactments today is the Prevention of Money Laundering Act. Please go to the Money Laundering Act. I have not seen a more badly drafted law in my life. And I'm a tax lawyer, so I can say that. You can see what I'm. If you go to the Money Laundering Act, there is what is called scheduled offenses. If you have got a scheduled offense, then whatever money you have is deemed to be proceeds of crime. And I'll tell you how absurdly it works. I've got my father's old Parsi friend who's 80 plus now. He ran a company. It's a true story. The company went into liquidation. They have not have a single check bounced. Every depositor has been paid. But 225 crores to a nationalized bank has not been paid. DRT proceedings are pending. What has happened is, this bank has filed an FIR in Bangalore, where the head office was, that this man has defaulted on 225 crores. Nothing happened. 2 years, the complaint has been filed, no further steps taken. Now, one of the scheduled offenses, section 420 IPC, which all of you know is cheating. One fine day on the 14th of June, I know because I appeared before the district court, is my father's old friend, they just arrested him. Because 420 is mentioned in the money laundering schedule, that case is pending, no charge sheet, nothing. He's sent to jail. There is no bail. Section 26 says age is a ground to grant bail. No bail. With great difficulty, we got him shifted to the Roypeta Hospital in Chennai. It's shocking, I must tell you, because it makes your blood boil. He's a Parsi gentleman. That doctor told him, wear a veshti, wear a lungi. He said, I'm a Parsi, I don't wear veshti. He said he's a disobedient person, they sent him back to central jail. The man is a shadow of himself. He's completely almost crippled. He's 1/3 of his size, and ultimately was released on bail after 14 months. Money Laundering Act. For no fault of his. Not only that, look at the shocking thing. Under Money Laundering Act, all his bank accounts were attached. House attached, but luckily we got orders saying he'll not be disturbed. For 9 months, all his bank account attached. His daughter from Bombay was sending him money for his daily existence. This is your Money Laundering Act. I'm telling you, just imagine your bank Aadhaar. And the most foolish thing about this act is, Trademarks Act is a scheduled offense, copyright is a scheduled offense, but income tax is not a scheduled offense. Now, what they have done is, they have put a rule, because suddenly people said, where is the rule for banks started issuing letters? In fact, Sham Diwan told the court, we gave examples in the court. The way it is being absurdly done is, there was a news item in the Times of India. A couple had their first child, where in some Gurgaon hospital, the doctors refused to give the birth certificate till they gave Aadhaar card. He said, my lord, what is the connection? I've got a friend of mine who runs this moderate Islam movement, Hafizur Rahman in Madras. His son is doing his 12th standard. He called me and said, sir, they're not giving me his hall ticket unless I give Aadhaar card. What shall I do? I said, come, file a contempt, I'll appear for you. He said, no sir, they'll victimize my son, I'll give my Aadhaar. This is really bullying tactics. Now coming back to bank, there was a thing you suddenly said bank, which is the law, where is the law? RBI said we are never given such instructions, embarrassingly. So now to cover it up, they issued a notification on Money Laundering Act saying that under Money Laundering Act, you must have your card. So one of the challenges we have taken is that if the object of the PMLA Act is to prevent money laundering, You can't use that power and frame rules for the purpose of banking. In other words, you can't take the Income Tax Act, make rules, and then issue some rules for having a license for having a scooter. The two acts can't be, you can have a ragbag legislation, you can't have a ragbag delegated legislation. So now the Aadhaar matter will start. What happens is this. In a sense, I don't know, it's going to be a Pyrrhic victory because now all 100 crore people have Aadhaar. There are still people who are defiant. Many people say we are not going to take Aadhaar, we'll wait. Our only objective is, we have no objection to Aadhaar. I told the court also, please amend section 7 and say every citizen of India will have Aadhaar. No problem. Like US, you got a social security number, have it, there's no problem. But don't make it voluntary there and keep harassing citizens again and again on this particular point. Now, coming to digital age, privacy in the digital age. The danger in the UK, David Anderson is a person who's given a report in 2015. You see, this whole thing came up after Edward Snowden's leaking of all the classified data. You must have seen. And there's a chap called Glenn Greenwald who's written a book, No Place to Hide. Right? And he was able to show all this data in the public domain. And it transpired that the National Security Agency in the US was having record of every single phone call made in the US. Who spoke, to whom they spoke, when they spoke, and for how long they spoke. Of course, they did not know the contents of the call. But every single call was monitored. And then a lot of articles came out and said that, look, this is a very dangerous situation. You can say always security, terrorism, crime, yes. But where do you draw the line? And David Anderson says the UK law at present, he says it's completely confusing and in a shambles. Now, there's a wonderful case in 2015 by called Digital Rights Ireland, where the EU had a directive where they could collect data from all European citizens and retain them, mass retention of data. That has been struck down by the European Court of Justice, saying you can't simply have mass retention of data, and they are given 9 principles or 9 safeguards, which we'll all place before the Supreme Court now. So the right to privacy in a digital age, as Justice Kaul points out, we are in a situation where the internet, the information technology is all pervasive and leaves a huge amount of digital footprints. Chandrachud puts it very good. He said this is recombinant because he says in digital data, the output can become the input from further output. So it can go on multiplying endlessly. So where do you draw the line? What are the security concerns? What are the things? As I speak, they have constituted Justice Sri Krishna Committee. And now I'll also mention 2 concerns which are pending before the Supreme Court. One is Aadhaar. The Aadhaar point is, it is a state-forced program. So privacy vis-a-vis a state actor. And the other issue, which is the Facebook and WhatsApp issue, privacy of non-state actors. Now, in the Facebook WhatsApp situation, what is happening is WhatsApp shares 4 pieces of data with Facebook. 2 petitioners, 2 students of eminent lawyers have filed a PIL in the Delhi High Court. Delhi High Court rejected it. It's come to Supreme Court. Now the Supreme Court is saying, what about privacy by non-state actors? They now say that Facebook and WhatsApp are like quasi-monopolies. You can't do without Facebook, you can't do without WhatsApp. I don't agree. I don't have Facebook. I don't have Twitter, but I'm very happy surviving. But then the point is, 99% of people have Facebook. It's a social networking site. You have a business networking site. The argument for WhatsApp and Facebook, they say WhatsApp is a messaging service. In WhatsApp, mind you, the message is encrypted. Even in the London terrorism, they refused, they said we are not able to give you what happens between the calls. So every WhatsApp call, every WhatsApp letter is completely encrypted, end-to-end encryption. It cannot be revealed to anybody. So WhatsApp says it's the most safe messaging service. Now Facebook. Now the proposal is, the submission to the Supreme Court is, we get large amount of data. What do we use it for? Facebook is free, WhatsApp is free, other sites are free, but how do these sites sustain themselves? There must be a commercial backbone to sustain this kind of manpower and things. So they say that we use it for targeted advertising, and the question arises, what is your right to privacy in such a situation? There the argument is, which has been a very good observation of Rohinton Nariman in that, he says, whatever you choose to put in the public domain is not covered by the right to privacy. You have to use it with a slight amount of caution. Now say for example, if I go to Google, and today suppose you go to Google and say I want to see, say for example, resorts in Jaipur. Tomorrow you will get on your, when you pop up, you will get hotels in Jaipur, flights to Jaipur and so on. So this is called what is called targeted advertising. There are tools which say that, you know, there will be a contract with Make My Trip or some Taj hotels that if anybody is asking for Rajasthan, put our ad on the thing. Now, is there a violation of right to privacy? The fact that I want to go to Jaipur, the argument is, in all these matters with non-state actors, privacy should be governed entirely by contracts. And that's why if you see Facebook, they'll say agree, then after 15 days they say I still agree, and after 30 days you have to say agree 3 times and say so. And there's a Lord Denning judgment saying if you give me a 100-word document and say agree doesn't mean anything. So now I think WhatsApp and Facebook, they give you the 14, 15 salient points which you must agree. So now it's left to the audience to see. I personally feel that as far as the non-state actors are concerned, it's a matter of contract. It's a matter of consensus. As long as they tell you up front what they're going to do with it, it's perfectly fine. I look at it this way. Everything you part with, you get a benefit. I want an insurance policy of say 50 lakhs. I have to go for a complete medical examination. My medical records are with the insurance company. But that doesn't mean they can use it further. They have to stop with that. If I want a 1 lakh policy, I don't need any report at all. I can just go for an ordinary policy. So everything has got a give and take. When I part with it by contract, then I can't complain about lack of privacy. At least as of now, Justice Nariman's judgment makes it very clear. What you have voluntarily parted with will not be covered by the right to privacy. Take an autobiography. I can choose, it's part of my decisional autonomy. I can have a tell-all autobiography or I can have a limited autobiography. Both are entirely within my domain. So I'll conclude my talk by saying we are at the cusp of a very, very international, a very, very landmark event, because there is, Justice Kaul has flagged the concern of Big Brother, Orwell's Big Brother, with so much of Aadhaar. You see, the whole difficulty with Aadhaar is, if it's seeded with every bank account, seeded with every phone, every school admission. I got a letter from Roorkee. The guy could not get his MTech thesis admitted because he didn't have an Aadhaar card. So I'm just saying that it is across the board, everything and everything you will have to get an Aadhaar card. And there was a cartoon in the Times of India, a man is about to be hanged and the person comes in and says, stop, stop, he doesn't have Aadhaar. So that was the extent of the Aadhaar. So now let us see what ultimately the Supreme Court says. And the topic is right to privacy in a digital age. My personal belief is, at the end of the day, whichever age we live in, the right of privacy, like the right to life, the right to be let alone, will always be present. And as Lord Brandis put it beautifully, he's saying at the end of the day, the most precious right, the most sacred right, the most sacred space is the right of an individual to be and become what he wants to. Thank you.
Thank you, sir, for that very interesting talk. I'm sure there are a lot of questions. So without, further ado, what I will do is, while Mr. Datar has a sip of water, I'll take 4 or 5 questions and then he can answer 4 or 5 questions at a time. Request, please keep the questions brief. Or if you don't have a question, you have an observation, please keep the observation brief. So that everybody else also gets, a chance. So do we have mics? Okay. So if anybody has a question, they can raise their hand and then I will, start from. Okay. One, Purnima. Sir. So if you want to sit, I'll take 4 or 5 questions and then we can. Okay.
So, on the issue of digital age that you said is a matter of contract, isn't it much more nuanced than that? I mean, for example, when my child was born, somebody said congratulations on Facebook, and the next time I logged in, I had diaper advertisements immediately.
Yeah.
I had not revealed that, I was a mother, but it was already there because somebody else had said so.
You're on Facebook, is it?
Yes. So, it's not my intention to reveal. So, I mean, I think it's just more nuanced than just.
Yeah, well, I'll just leave. I'm appearing for Facebook, but doesn't matter. Yeah, Mr. Sybil is appearing for WhatsApp and I'm appearing for Facebook. See, the point, I asked the same question because my wife told me the same thing. The moment you say something, like you said, happy birthday, to the child, and they'll say, I think of diaper. For example, like, you may mention something about photography, you'll get camera advertisements. Now, I believe what the people tell me is there are threshold levels of settings. You can say, don't reveal at all, reveal this. So I don't know what privacy setting you have set yourself. And the idea is, what they say is, this is highly beneficial. Now, that's the argument of Facebook. Now, suppose there's a company, you said diaper, you got diaper ads. Now, just imagine for a diaper company, they will send it to you. They will not send it to me or Mr. Acharya or Mr. Naganan, because we don't need that ad. So they save that money because it will only go to a targeted audience. So they've got an arrangement. For example, suppose you're in the market for a two-wheeler. They will not send you an ad, say, for example, for a truck or a high-end car. So they say the whole thing is targeted for the purpose of, and according to them, everybody knows that when you use Facebook, this information is going to go. And it's not just Facebook, you go to Flipkart, you go to Amazon. Like you go to Amazon, you buy a book, immediately you'll get, would you also like to see, they'll give 5 books. Suppose I ask a book on, say, the history of Karnataka, they'll give me 5 other books on the history of Karnataka. So this is all what they call targeted advertising, and what is it called? Enhanced customer usage. That's a jargon they use. I don't know I'd like to know what the audience feels. You think that Facebook is right in, like she said about the baby, immediately she got diaper. Is there anything wrong? Is it a violation of privacy?
I mean, there's an extent.
Yeah. Yeah.
There was an article about this Facebook and other social media apps where they say that Facebook knows when you are bored, when you are depressed, bored. So they in fact have recommendations. They know more about you than yourself. Okay, so to that extent, and they make suggestions like, at when your say weakness is out there, probably you are willing to shop or splurge more. So they try to take this probably,
See, I'll tell you what, one thing I'll tell you, I do not know what is the empirical evidence to show that they've analyzed 500 Facebook customers and they said she's depressed, he's elated, he's not so, and what is the basis of that data? I don't know what. You could be right, I don't know, but I'm just saying that empirically evidence, if I'm going to log on to a particular Facebook site, frankly, I'm handicapped because though I appear Facebook, I've never used Facebook in my life, so I don't know. But I think that I don't see, if my wife is using Facebook to share photographs or to say something, I don't know if the person can know whether she's bored or she's saying and so on. I don't know.
I think we have one second. Kishore, I'll take, there are a few hands here, then I'll come to this side. I'll go with the questions here first, 3 or 4 questions here, and then I'll come here.
Yeah. I don't know how far that is true, that that if you're looking into your laptop, your photograph is being sucked in and sent out. I don't know whether it's possible to do that. I don't think it's possible.
Okay, please, can you raise your hand and then otherwise we'll just give, Vishnu, Rupa, and okay.
Sir, building on the theme of how you said it's with non-state actors, it's a matter of, contract. So do you think it's fair for a company to deny you their service altogether if you don't agree to their privacy policy? And I think under the reasonable security practices rules, they have that right. The rules do say that. But think about maybe not right now, but maybe in the future where WhatsApp is the primary mode of communication. If someone doesn't agree to their privacy policy, they can deny them their service, and essentially that person cannot use WhatsApp to communicate with 99% of the population. So to that extent, isn't that a little unfair for a person to be denied that service altogether? If yes, what could be the compromise?
Actually, what you have said is one question raised by the petitioner, that WhatsApp is like a quasi-monopoly. It's almost like a monopoly, therefore. But you see, the point is this. The argument on the other side is that WhatsApp is a messaging service. And why WhatsApp is popular is because it's free. When you send an SMS through a telephone service provider like Airtel or Vodafone, you get charged for it. And WhatsApp is free. Because of certain reasons, it costs them some money, but it is virtually free, and you only pay for the data usage and nothing more. But I think that, speaking for myself, not because I'm appearing for one of the parties, but I feel it's entirely a matter of contract. It's a matter of give and take. If you want the services of WhatsApp, see, for example, you got a WhatsApp group, you got, say, for your law school group, this group, all this comes at your fingertip. Just parting with 4 things, your phone number, your model of the phone, etc. I don't see what is the degree of harm in doing that. Similarly, for Facebook or LinkedIn, if you can communicate with your relatives all over the world at no cost at all, no need to make an STD call, no need to make an ISD call, no need to write any letter. If you can do all at free, and all they say is just allow us to use that information for advertising, it's up to you to take a call.
Rupa?
Yeah.
Yeah. Rupa and then Mr. Nagaman.
So I actually, I think it's a great thing that's what's happening. It's just evolved from, those billboards that are placed appropriately. They've done a lot of research. And instead of placing it in this corner, they're placed in that corner. During rush hour, everybody sees it. It's your choice whether you want to buy that product or not. I don't see what the difference is between that and what is happening now. You have a choice not to buy the product. And I'm thinking that's how, life is evolving, and we have to evolve with it. So I agree with you. It's a private contract.
Facebook will be delighted to hear that. No,
Mr.
the other thing is, I'll tell you what, the other point, one other argument we've raised is, out of so many millions with Facebook, who has complained that their intimate data has been revealed through Facebook or Flipkart or Amazon or so on? They say there are certain protections they've got, they will not reveal that. And it's only for the purpose of targeted advertising.
Yeah, just a small comment. When Uber challenge to the regulations of the state government was there, one argument which our High Court heard and accepted was, it said that one of the regulations said that where you get on the taxi, where you get off the taxi, that has to be stored, and it should be available for state authorities if they need. That's the regulation. So the argument was that this is a serious violation of my right to privacy, because why should anybody know and keep a record of where I go and where I should come? Our answer was that if I go in a public transport, and Uber is a public transport vehicle, suppose you go in an aeroplane, you have to give your details. Suppose you go in a train and you buy a ticket, you have to give the details. What is wrong in having that information? So I think the exception to the rule which laid down by Supreme Court really is that if you opt to go into the public sphere, then I think your right of privacy is naturally curtailed, and I don't think there's any serious something
And
wrong.
talking of Uber, I'll tell you an example. Like, I have used Uber, and they ask you a question: your location should be disclosed or not? And you can say allow, don't allow. So I put don't allow. Now my son has put allowed. Okay, and I remember some time back when in the thick of this privacy case, we went to a Murugan Idli center in Chennai. And as we entered, me, my wife, my son and my daughter entered, my son gets immediately a ping on the notification, says, "Good morning, Rishikesh. Welcome to Murugan. How do you find the restaurant? Rate it." So he's being tracked from which satellite God knows. And the moment he enters that particular restaurant, he's asked to rate that restaurant. So that's the way, it's some kind of an indirect surveillance. But as Mr. Naganan says, you opt for it. You say, okay, let people know where I am. So,
Okay. I'm sorry. I need to go to that part of the audience, and then I'll come back. Kishore?
Couple of things. First of all,
now I'll ask you a question. Does it make any sense to link Aadhaar to bank? You tell me that later as a technocrat.
I'm more worried about telecom than bank. Bank is okay.
Ah.
I'm worried about Airtel.
Yeah.
That's what videos I'm watching. No, but this issue about location and companies knowing where you're going. Now, there have been cases where internal people in Uber have harassed their own employees and contractors by knowing where a particular woman has traveled 4 days in a week. They've tracked that. They've actually physically abused the woman based on some patterns of her behavior. So I don't know if it is that simple. First of all, I don't think of Uber as public transport. I don't know if anybody outside the legal fraternity thinks about it as public transport. We think of it as private transport. We think of buses as public transport. So there is a challenge there. But the bigger issue, or the other issue for me about things like Facebook, The choice of pushing an ad for a diaper to a woman, in her late 20s who's been congratulated about a baby, so on and so forth, is not made by a human being. It's made by an algorithm.
Yes.
It's made by a system. Is that an attack on privacy? It's just a piece of software. I didn't tell anybody that you're going to have a baby. My software pushed an ad to you. So what's the problem? Now, taking that further, there will be lots of choices that systems are making. This is advertising. Tomorrow, choices about what car I buy, where I go for my insurance, whom I hang out with, what friends I make. I mean, the list of friends that it throws up. Somebody I haven't seen in 20 years suddenly pops up there. As a technical guy, I wonder, how did it know that I knew this person? How did it know that I went to meet a doctor last week to get my back checked? Those kinds of things become more worrying because that is automated. It's not human being. So I don't know how the legal process would even address
But I
it.
don't know whether it's worrying. For example, I'll just tell you on this thing. My friend of mine was in Seattle, and his friend works for Walmart. And I was fascinated to know that, in Walmart, everything is like an algorithm, as you say. And suppose they know, for example, that Bangalore is going to have heavy rains. Today is Friday. On Tuesday, they're going to have heavy rains from Tuesday. I believe the system will automatically send umbrellas to shops in Bangalore. So they'll know that this is going to happen in the weather and this is going to be the requirement. All done by algorithms. And that's what the other big difficulty in the Supreme Court is. They want to check on metadata. You see, but the whole difficulty is, as far as Supreme Court is concerned, as lawyers, I'm ignorant, the judge is ignorant, the lawyer is ignorant, and I don't want them to pass some orders which will hurt a lot of people. There could be a lot of collateral damage. That's why they formed the Sri Krishna Committee, and I think it's a matter for Parliament to ultimately decide. I'll tell you one more thing. Under Section 43A of the Information Technology Act, they have framed the 2011 rules, where they've got certain amount of what they call personal sensitive information, PSI, which can be protected. Now, according to them, it has to be of a higher threshold. Now, since we are working on this case in the EU itself, Germany has a higher threshold limit of data protection vis-a-vis the others. Yeah.
Okay, any more questions on this side? Sorry, before I go. There's at the back. 1 second. Use the mic, please.
The question I had relates to data privacy when you talk about non-state actors, and you mentioned that really the rationale is, ability to mine data for advertising. But what about fake news which feeds biases and has, basically destabilized democracies?
See, I'll tell you what, I don't want to get into fake, because see, these are like this person who was this Uber employee who was using that data to track a woman and harass her on someone. These are all aberrations which really don't get into the main problem.
Aberration which resulted in, probably the election of, the most powerful man on earth.
Yeah. I know. But you see, I don't think that's a issue of privacy and the fake news may be a case where the Russians give fake news. No, I don't know whether we are talking of Facebook. I mean, the fake news in the Russian context and Trump's election. Facebook gave false news with regard to Trump. Huh? Yes, yeah. Maybe they marketed Trump better. What you call fake news. Anyway, I think disasters happen. So.
Okay, Aditya, then Yajas, and then Samir.
I'm just trying to make a case against the targeting marketing by actually taking it outside the virtual space. And I think the effect is accentuated when you think of it in the normal market space. The same diaper example, just think of it as walking down the street and you're talking to your friend, and there are 10 people start surrounding you and start saying, here, buy the diaper. I'm really looking at this not so much as targeted marketing as much as it is actually eavesdropping, where I'm having a conversation with someone, I'm being eavesdropped on, and that is being used to invade my privacy. And it really goes back to the classical notion of the right to being just left alone. And I think that is where this invading, today it's fine, it's just selling diapers. In 1926, the horrors were, we couldn't foresee them. I think standing in 2017, I don't know what this eavesdropping can lead to some other day. So I just think we are giving chance for an Orwellian 1984. So I don't know.
I see, that's a point of view. I agree. There are people who think that could be an Orwellian 1984. Now, I'll tell you what, as far as Facebook is concerned, it's like you said, you're walking down a street. Now, you may choose not to tell your person about that impending pregnancy, so people around you come and say, and you say that instead of physically people coming to you, things are bombarding. Now, every Facebook user knows that he's going to be subject to advertising. Every Google user knows that when he opens Google, he's going to get on the right-hand side pop-up advertisements. So you just have a, what you call a cost-benefit ratio. Is your privacy so important that you don't want to be bombarded with ads? Then don't use Facebook. Now, I'm not using Facebook because I don't want this thing, but I personally feel it's a waste of time. But that's my choice. I'm not on Facebook. I've never seen a Twitter in my life. There's nothing wrong. Now, there are ads and items saying that I saw a thing in Times of India. You see Times of India on the op-ed page, you'll get the most astonishing thing, that if you eat tomatoes, you'll get knee pain or some kind of rubbish like that, and that people beyond 40 start thinking of women at the age of 20. Some kind of rubbish keeps on coming in Times of India. So one other thing was, and my wife showed it to me, people who don't use Facebook have got strong antisocial behaviors and are dangerous people. So that is obviously planted by Facebook.
So I'm sorry, if I may just take
Can we? We'll come back to you if there is more time.
Thank you.
Yeah, just
But
and
this
then
time, the
Samir.
actual report in Times of India that non-Facebook users are antisocial and.
I'll come to you guys. You just.
A small observation and a quick question was, firstly, we talked about the diaper advertisements a lot. I read a report and there was quite a bit of news recently or some time back about how retailers now can predict based on your consumption patterns. They can tell you that you're pregnant before you realize it. So a month and a half after you're pregnant, based on what you've eaten, where you went and shopped, the mood that you displayed, they can probably tell better than you can. A quick observation. The second point is,
where did you get that information?
fortunately in the newspapers.
I mean, you don't need any more pregnancy tests. Just dial your number.
Yes, sir, you had mentioned and you briefly mentioned it about how our laws in India for non-state actors, specifically on privacy laws, need to go beyond just sensitive information. And sensitive personal information today is only things like biometric information, bank account information, things like that. And it needs to evolve more than that because, like you said today, with the right software, just based on your name and where you were, on every Monday for the past 10 weeks, I can tell all kinds of things about you because the computer program, the algorithms that we have today are so powerful. So question to you is, do you think that the law, which is the forthcoming law on data privacy, will take us beyond that, sort of extend the whole framework to what we don't consider generally sensitive information to include things like my name, my age, and my address? Can our economy support it? Can a system like India support that, where we require every company to get consent before collecting my address, before collecting my phone number, where they send that? Because today they don't need to. They don't need to ask me my permission to collect my phone number and my address. That's not sensitive, but they do require my consent to collect my blood group or my biometric information.
Well, I'll first of all mention one thing. One thing I find astonishing, because I've been meeting people and so on. People are very worried about the misuse of data by Flipkart, but they're not worried about the misuse of data by Aadhaar. That is the most worrisome thing. You see, I have no time. If you see Section 17, Section 47, Section 48 of the Aadhaar Act, there is absolutely no restriction on what they can use the data for. That is a more worrisome part of it. And not that I'm not pro-state or but I'm saying that's the larger concern we should have. See, today it's okay fine the government. Tomorrow if it's a rogue government. Now you got your Aadhaar card, all right? If you got your Aadhaar this thing, and if you seed it to your number, and in a political rival situation, I can simply make sure your phone is disconnected. I can have a system where these Aadhaar numbers the phone will not be used. You can do that. And there are so many other things, for example, there are cases where, in fact, I don't know if you're interested, I can say there's a very good IIT report by Delhi IIT on what are the defects in Aadhaar. And they say it can be tweaked. Now you take your digital fingerprint. What stops you from taking it away and using it else? That can be recorded, that can be stored. And in England, this footprint, this thumb impression was sought and was deleted, saying it's most dangerous. England thought about it and deleted. Now that's as far as Aadhaar is concerned. As far as non-state actors is concerned, because we are working at it very deeply, one issue is going to be the conflict between informational privacy and decisional autonomy. Now, can you make a mega law and say that Flipkart will not do this. Whereas if I say I have no problem, I want targeted advertising. I don't want to be bombarded with a diaper advertisement because, I've got a granddaughter now. Why should I need something more of old age care, geriatric products. I may require that. So I want advertisement only which suits me. So in fact, I'll say it's a service. I don't like in a newspaper, I see the newspaper, I see everything from a housing project to a jewelry to everything. Whereas when I see Facebook, I just see what's relevant to me. So I could think of that. And on the economy, I don't think. I think that as far as Facebook, Flipkart, everything is concerned, I don't know if you can make a law which applies to all kinds of players, because what will apply to e-commerce may not apply to social platforms. So it's going to be a very, very difficult task. And I personally feel that the EU, especially the working paper 29, is going overboard. They're getting say this thing, and they assume that by giving information, I have no objection to that. And see, as far as your phone number is concerned, it's there everywhere. Your phone number in your bar council, it is there. In your hospital, it is there. In your college, it is there. Everybody is there. Yeah.
Okay, Sameer, and then I'll come to this side, and then I'll come back. There are two people.
Thank you.
One simple question as a layman, can you outline some of the risks of linking Aadhaar to the bank account? As a layman, what are the risks I would face?
Actually, very frankly, I'm going to meet some I've met certain people from the banks. We had a meeting, and they say that there is absolutely no advantage of putting the Aadhaar with your bank account. They have got the KYC norms, know your customer norms. They've got the e-KYC norms. Now, by adding simply Aadhaar, there is no advantage according to the bank officials. I'm not a technocrat. I'm having another meeting with them later next week as to what could be the possible misuses of the Aadhaar. Because you see, the point is this: if you see the UK laws, especially European Court of Justice, one of the 9 points is, they say when you have a restriction, the law must say why you want this particular information. Nobody has told why Aadhaar should be linked with this thing. And if you see day before yesterday's Times of India, the Delhi edition, I was coming back from court, I was reading Delhi, the Minister of State, some Hardeep Singh or somebody, he says, now all property sale deeds, you must have Aadhaar card before you can buy and sell property. What is the reason? It is to prevent black money. I mean, it's like saying that I'm going to give Aadhaar card before you enter a bar to prevent drinking. Property is black money. What are you talking about? I mean, and people just buy it. He speaks at a seminar and says, and there's a proposal now. You can't sell or buy a property without Aadhaar. Now, anybody who has bought a property, at least in Pune and Madras, I can tell you, they take your photograph, they take your thumb impression, PAN card, about 2 lakhs, PAN card. So all this is done. And now you want Aadhaar. So see, nobody has stopped and said, what is the need? I can understand for a person who wants a house, the fertilizer subsidy or this subsidy, because who knows Arvind Datar in some village? Manrega, lakhs of people, and many of these poor people may not have a birth certificate, they may not have anything, so the only identity is the thumb impression. And I was told by Usha Ramanathan, who's done extensive work, that people who do hard labor, their thumbprint doesn't come. People who do manual scavenging, their thumb impression doesn't come. And we have got reports of people in Bihar who have been denied. See, one other prayer we are making is, if I got other evidence to show that I am Arvind Datar, allow it. Don't say just because my Aadhaar doesn't work, I may have voter's ID. Right? Everybody is a voter. So if I don't have my Aadhaar, don't say I won't give you ration. If I produce my voter ID card, what's wrong?
Sridhar?
That was really a fascinating talk.
Thank you.
I just want to shift the arguments that have been going on. My background is I am a medical person and medical doctor.
Yeah.
And I dabble with this new genetics that's coming. And actually one of the scary things for me, again, is the sort of information that hasn't been discussed about. Actually, something that has gone past Moore's law, which all the techies quote, is that the number of transistors will double every 18 months or so, right? So the costs of genetic sequencing have actually fallen even faster than Moore's law. And today, to sequence the full genome of a human being is under 50,000 rupees. Your 3 billion bases, the sequence. And this is again digital data. So I was curious in the arguments that are being made for the right to protection of privacy, whether the genomic data, which is again in the digital format and so is very easily movable, has that been brought about, and what are the thoughts?
No, Aadhaar is promoted by 1 or 2 people who have got their own agenda. Somebody will come with a genome project, they'll start promoting it. Somebody promotes GST, you promote demonetizations, promote your pet project, you can have genome and project it. But right now it's only thumb impression. Actually what happened was the basic, if you read the book by Shankar Iyer, Shankar has written a book on Aadhaar. It is more pro Aadhaar. I don't mind. It's his point of view. But he says the whole purpose of Aadhaar was to identify, there was a lot of leakage. Rajiv Gandhi's famous thing of only 19 paise reaches the person, 81 paise gets leaked. So how do you say that a fertilizer subsidy, a cash subsidy reaches Mr. Subramaniam or Mr. John at the village level? That was how the whole thing started according to Shankar Iyer. Yeah. Okay. And that Ram Sevak Sharma was the one try. He was one of the first persons who started this for targeted delivery.
I don't know.
And talking of genome, you can know your entire background. I'll tell you a small story. I don't know if you remember the book called Roots. So sometime back, Alex Haley wrote a book called Roots. And there was a huge project in US where you pay $1,000 and you find your roots. And the joke was you pay $1,000 to find your roots and then pay $5,000 to hush it.
Sir, there are still some questions. Are you okay?
I'm okay.
Okay. So
my flight's in the
first
morning.
you, then I think you had you're okay. 1, 2, then the gentleman at the last, and then after that, Lakshmi. Okay, I think you need to switch it on because it's not on already.
Thank you. So talking about sensitive data and privacy in digital era, even before the privacy judgment came about, a couple of high courts, including the Karnataka High Court, has recognized right to be forgotten.
Right to be forgotten. Yes.
So do you think this privacy judgment will pave more way to right to be forgotten? And if yes, where should the line of difference be drawn between right to be forgotten and right to know?
Right to be forgotten
and right to know. Where should the line of difference be drawn?
I don't think there's a line, any meeting point between that. One is the right to be forgotten. I think it's a facet of the right to be left alone. Like in the sense, what do you mean? Right? I mean, you should not be on the digital space. Your name should be deleted if you want to.
If there are any criminal records in my name, so the basic argument is that I would want to move on in my life once I've served my imprisonment. That's one argument when it comes to right to be forgotten. But when it comes to right to know, if I'm an employer, I would want to know the records of my employee. But if this right to be forgotten is enforced, and if search engines like Google remove the information, how me being an employer would know the information about my employee?
I don't know how they're going to solve it. But for example, let's say I'm a criminal and I've served my sentence and 20 years have passed. Why should my record? I could say, okay, we can have perhaps a law saying beyond 20 years, don't maintain it. So I don't have to have that hangover of being criminal for the rest of my life. So it could be a balance. But at the moment, from what I see, either Sri Krishna committee, there's right to be forgotten is not at all on the horizon agenda or on the radar of anybody. It's more on the right to privacy. You see, the point is this, what they are doing is collection of data, storage of data, and usage of data. They are the three basic buckets where they are focusing on. How do you collect the data? How do you store it? And once you store it, on what basis can you part with it? Whom do you part with?
So do you say that
for example, in the EU directive, there was a collecting agent and they said that they could retain mass data and give it to anybody and everybody who wanted. They said that you can't do. There has to be overpowering state interest to allow your data to be thing. But on right to be forgotten, frankly, I've also not read much about it because that's not part of the argument so far. But I'll see what I can do.
Yes.
That I heard recently that nowadays they're asking for Aadhaar card even for cremation, and they delayed.
Cremation of the dead person, or?
Yes.
Are you serious?
Yes.
Okay. I don't know. There are the.
I should put it in my petition. On talking of cremation, I used to keep joking. Service tax. Somebody said, service tax is from life to death. You have to pay service tax. I said no. When you are born, there is no service tax because hospitals are exempt, and when you die, you're not, because crematoriums are exempt. So after birth and before death, everything is covered by service tax. So this is an exception. But it's very shocking that you have a dead. So you won't cremate him? This is atrocious.
Well, excuse me. There.
Huh? Go to Banaras,
Good evening.
But do you have any information on this? Excuse me, do you have any actual record of this? Because I can put it to the court. Of course, it's a stray case. See, one more thing how it happens. In court also, a stray case will not decide the law. These are all very, very rare cases, Unless there is a circular or a rule that even the dead person has to be given Aadhaar.
Yes, sir.
Good evening, Mr. Datar. I'm Arvind Datar. I've got two observations.
Hello, sir. How are you?
Hi, how are you? First one is on this right to privacy you're talking about. Basically, it's about trust. Trust.
Trust, huh?
The government just does not have trust. And therefore, it is coming out vague notions of trying to link Aadhaar to everything about yours, from your shoelaces to your hair. So, Aadhaar...
No, I mean, with your background, what could be the policy decisions behind linking everything? I mean, what is the reason? Is it just some kind of snowball effect? Ministry of Company Affairs does it, therefore banking must do it, therefore, I don't know.
No, definitely it's a snowball effect, but it's actually leading from mistrust. If you have trust, then these things will not come out, because as you yourself mentioned, or some of our audience has mentioned about the fact that when the KYC is there, KYC is there and eKYC is there, where's the question of an Aadhaar again being put into this one? Just now I've received one mail that I have to link all my mutual fund portfolios also to Aadhaar before December 30th. And then if not, then I'll lose my money.
You know, this is so unfair. Mr. K.K. Venugopal gave an assurance that they will instruct all the banks not to send this message and postpone it to 31st March. In fact, I'm going to take it up next week in the Supreme Court.
No, this is not even a bank.
Every day, no. What
this is Karvi consultants who are sending me this one, that I should link all my mutual fund, this one portfolios to Aadhaar card. Does it mean that every private act of any individual in the country has to be linked to an Aadhaar card? Is that what we are looking at?
Yes.
I don't think we are looking at that.
And see what will happen is, by the time the case is heard, if you already linked your Aadhaar card, it's a fait accompli. See, what's the point? It's too late later. Unless the court directs deletion of all this.
No,
and in fact, I'm meeting some bank people. I want to know, I was asking Mr. Kishore also. See, the point is, I can understand like what Lord Coke said, what is the mischief? What is the problem? If this is a problem, is linking Aadhaar a solution? Then I can understand. For example, for the Manrega, how do I know it is Mr. Jadhav who in the village? Thumb impression, there is no confusion, so no problem. But what has it got to do with the 12th standard hall ticket or your M.Tech thesis? No connection at all. So what is the purpose? Nobody's answering.
No. See, when we were asked to implement the Aadhaar card about last year on the seeding purposes, the instructions which were given clear to us was that in case if any citizen is using government benefit, that's all, period. Beyond that, it was not to be given.
Exactly.
And we were linking up to that. But now I see that by putting a money in a chit fund is also asking an Aadhaar card.
No, even if you want to become a director of a company, you have to give your Aadhaar number.
Yeah, no.
I mean, I'm a PAN card holder. And if you see PAN card also, once my PAN card is there, see, one more thing what you can say is, again I say, give it decisional autonomy. If Mr. X wants to link his Aadhaar, let him link it. But don't say, I will close your bank account. The proviso in that money laundering rule says, if it doesn't deserve, if you see the last proviso, if you don't do it by 31st December, the account shall be closed. What do you mean closed? Will I not get my money back?
No, that's what I'm trying
to... And suppose on 1st January, suppose you're a pensioner, where will your pension go if your bank account is closed?
No, that's already happened in pension also. In pension, they have come out with Jeevan Praman or some certificate has to be given. But none of the pensioners know about it. So you have to go there. Every year you have to give a life certificate that you're alive.
Yes, I believe so. That's a rule that,
No, I've got one notice to me already that I have to go and do it. So I tried to go to the bank. The bank has kept only one thumb impression, this one, because in Aadhaar, if you have to seed it, you have to give a thumb impression, otherwise it will not activate. And there are hundreds of pensioners all over the country. And the State Bank of India very generously has kept only one. With all the people with all their broken leg or this one and all coming and trying to take it. I said, you have never even informed anybody that the Jeevan Praman also. So what is happening is, as you told us rightly, there's another problem in this hand. Every day a technology comes out and they want to say they are better than the previous one. You continue the last technology and ask the add-on of the new technology.
New one, exactly. Absolutely. I don't know what Supreme Court will ultimately say. It's really have to put a stop somewhere.
Yeah. Lakshmi.
Is there a proposal that they're going to unify and have a single, because now that you're linking Aadhaar to everything and it's supposed to contain your biometrics and your other details. instead of carrying multiple cards in my wallet, am I going to be
Actually,
carrying
you're right.
one?
I've got such a fat. You've got your PAN card, you got your driving license, you got your Aadhaar, you got this, that. I don't know if they're going to use Aadhaar for, I mean, like a SSN number, social security number. I don't mind if they have one card and it applies for everything. Then I don't have to, for my pension or my income tax or for my...
Is this moving towards a
No, I don't think so. Each has got his own silos. Each one is in his own purpose. There is no proposal. PAN card will continue. They may want to have some kind of a necklace kind of situation where Aadhaar is the link with all. It's linked to PAN, linked to your bank, linked to your mutual fund, linked to everything. I don't know how they're going to make it up.
Okay.
Yeah.
Can you take the mic, please?
For example, in railway protection post, for RPF, missing children, they are getting so many children last week also, and this is helping them to trace their parents.
Okay.
They cross-checking is. Recently also, like 500 children they found. Out of 500, 95% of them they managed to trace their parents.
Okay. No, it's a good thing. I'm not saying no. What I'm saying is make it voluntary. My only difficulty is missing children. Yes, so all this is definitely plus points. In fact, for Election Commission, now they have made, see how the press misreports. Election Commission, I told them you can't make it compulsory. So they said you can have your thumb thing. The purpose of Election Commission is, suppose from Chennai I shift to Delhi or I shift to say Bangalore. Now I want to shift my voter ID to Bangalore. This suggestion was if I got my Aadhaar, if I got thumb impression, I don't need, I can simply come to the Election Commission office here, give my Aadhaar number, so my identity is revealed and my name will be removed from the voter list in Chennai and added to the voter list in Bangalore. That's the benefit of Aadhaar. I don't make it voluntary, but I may choose not to have Aadhaar and I may come and say, look, I may want to go through the detailed process. My only quarrel is, if your Section 3 of the Act says it is, you may apply, it's your choice, don't push it down the throat of everybody.
Sir, I have 2 questions and then we'll start. Sir, one, by most of the judges in the privacy judgment, in Puttaswamy's judgment, they talk about, balancing the right to privacy and other interests, public interest and all. Where do you see that going? I mean, in terms of balancing, because, this balancing is what causes, most cases to go to constitutional benches and the issue. So where do you see this going in the context of the privacy?
This is a worldwide problem because you take the WP29 directive in Europe, you take the data David Anderson's article, his report to Her Majesty's office. It's a huge, huge problem. Where do you draw the balance? I mean, it's always difficult. He may say this is tilted towards the privacy, private space and less towards the state. Somebody may say there's too much of state intrusion. So ultimately they want to have some kind of thing and they have not succeeded so far. What is the basic thing? I think that, look, if you can store the data and once you can part with it, subject to some kind of security that, like in England, there's this called as a information commissioner. So Anthony May was the information commissioner. Now some David Kennedy is the information commissioner. Information can be parted subject to the rules framed by him. And he's the supervising authority who will supervise passing of information of the citizens which is collected in a central nodal place. But it is going to be a problem where to draw the line. And within Europe there is a conflict. Germany has got a higher rate, France has got a lesser threshold.
So the second question is about, I think we've been talking about contract and consent. I think I was part of a seminar that Alok and I participated about 2 weeks ago. And Rahul Matan, who is also in the past had also drafted a privacy law, he made an interesting point. He said consent has become meaningless in the digital age, partly because of the reasons that Purnima mentioned that, you don't know, you may not give consent, but because of people who know you, they assume they can make choices about you on targeted advertising. And even if you give consent, because the enormity of dealing with multiple websites and multiple service providers, there's a huge, privacy policy, and consent basically has become meaningless. So is consent now, so if consent is, the two parts of this question, sir. One, if consent is meaningless because other people you are interacting with have given their consent, and thereby decisions are being made or targeted advertising is being made to you. That is one part. Second one is
enhanced customer experience.
Enhanced customer. So that's just one example, but it could be used for something else. Like, for example, do you know that you are only interested in birthdays of XYZ, rather than, ABC, things like that. I think apparently those things are also easily. The second point is, will these standard privacy policies, will they also be treated ultimately like standard form of contract? And therefore, the consumer will have a right to challenge it at some point.
I don't agree that consent is meaningless because, for example, in Facebook, you got different levels of secrecy settings, privacy settings. So consent is important. Now, what it could happen is that as far as this price-sensitive information is concerned, in the light of the 9 judges bench, again, what they have said, it is a mixture of informational privacy and decisional autonomy. I may choose what part of my information can be put in the public domain. Like in Facebook, it's up to me to put to what extent of my private life I want to put on Facebook in photographs and so on. And I can say share with the world at large, share with this group, don't share with anybody. So all this is part of my thing. So I don't think consent is meaningless. I think what they may say is that as far as the privacy policy is concerned, look, I don't know how they can have one law to fit everybody else, like a contract act. Like you still have got the basic offer and acceptance. I say that, look, if you want to use Flipkart, I consent. I want you to buy books on Amazon, I consent. So once I put Amazon and I'm going to buy this book, I can't say that don't put me suggestions of other books. So then I don't go to Amazon. So I don't think that consent is an issue.
It's only between you and others, but not between you and Facebook and their partners. So they cleverly say share this photo with friends of friends, public, only I can see it. But I don't think that stops Facebook or their partners from seeing all of that.
No, they're very clear on that. That's a privacy. It's not that Facebook will share with Instagram and so on. It depends on your privacy. You say don't share with anybody means don't share with anybody. That's all.
Okay, we will have
That's
to.
their policy. I do not know because I don't use Facebook.
See, unfortunately, we'll have to end. So I'll end with this last question because he's had his hand for a while.
So my name is Rahul Kapoor, and I'm not a lawyer. The closest I get to is being a friend of a lawyer who is Navneet Chok.
You're Aadhaar owner, customer?
But it was a fascinating speech, and I wanted to just see if I could connect a few things. One is, of course, on Aadhaar, one quick observation is that at least one place where Congress does something and BJP follows with a lot of passion. But the question, sir, is about this movie, The Enemy of the State. Will Smith movie talks about this law which the government wants to promote on Surveillance Act to counter anti-terrorism. And there's this lawyer who wants to oppose it, saying that this will take away the privacy of people completely. What they do then is, in this automated world, is they conspire against him, have a false case of murder against him, block his bank cards. He can't enter his own house because it's automated. He can't make, they have false evidence. They take his video clips of some other time in the past of his girlfriend, present that as the current affair that he's going through with his girlfriend, and shows it to the wife. She files for a divorce. Now, guy doesn't have house to go in, doesn't have money. He can't have his bank account. He's completely an individual now. My question to you is this: can we not learn from this process, from that movie a few years ago, and figure out these things can happen here?
Yes.
Your friend, you spoke about the Parsi man. It was just one small incident, but imagine if digital medium continues.
That's a major concern.
Huge problem.
In fact, after Eric Snowden's point, then they say no place to hide. That's a big question. And as Harsh said, the main difficulty, what every government in the UK or they say is how to balance the need of the state to curb terrorism. In fact, WhatsApp had a problem with the UK. The guy was sending messages on WhatsApp, the man who drove the truck and killed. But still, it's encrypted. They will not share it.
Okay, thank you. I'll have to stop there. If there are any other questions, Mr. Datar is here. You can ask him questions.
I won't take much time. Thank you, sir, for the brilliant speech. And I know we followed up a lot with you. I've personally bothered you at odd times to make sure you come here. And we're really happy that you could make it.
Thank you very much.
We're thankful to Sri Naganand, sir, for making it here. I would request Shruti to please hand over the memento to Dr. Mr. Arvind Datar. Thank you to IIHS for allowing us to use this venue. Thank you all for coming in for this lovely evening.